Morning, everybody. It's good to see you all on Sunday morning. Since the lockdown has started, it is very difficult for people to figure it out which day it is today. Is it a Monday or Sunday? So, and the way I said last time, we all start our day very late. So, 10 o'clock also turns early morning. Lots of people might be busy doing their breakfast even. Yeah. So still, you people have contributed your time to come down here and, have shown the interest to attend this webinar. I really thank you very much to all of you. I also thanks Mr. Samruddha Bharat and LEXGENUS to organize this webinar for us. And let's not waste much time because I'm sure lots of you are waiting, eager to listen from Advocate Sujeet Salkar, because I remember his last session, which was very interactive and very interesting. Like you, even I'm like really excited to listen from him today. So he's going to attend a topic which is silent features of the Industrial Relation Code 2020. Right, and I'm sure he will give us the detailed idea about it, and at the end of the session we will also have a small answer session through that. All right, so I will request Mr. Salkar, please, you can start with the presentation. We all are really excited to hear from you. Thank you.
Today's today's topic for discussion will be salient features on the Industrial Relations Code 2020. Now, the most important changes we will be discussing today to the Industrial Relations Code 2020. This statute, basically, Industrial Relation Code replaces three acts. One is Industrial Disputes Act, then Trade Unions Act, and Standing Orders Act 1956. Now, these all three acts have been merged together and one single Industrial Relation Code 2020 has been brought into force. It has not come into force yet. It has been passed by both the houses. It will come into force. All these legislations will come into force in somewhere in December, maybe, possibly. Now, the important definition is definition of employer. Now, this definition of the employer, they included the contractor also. So this is the important change they have brought in. So all the disputes regarding who is the employer is resolved now. So employer includes a contractor. So this is a very important change they have brought in. Then the definition of employee also is there. There the definition is includes managerial, administrative, and supervisory category of employees. But in the code, if you find in this industrial relation code, most important definition is a worker. So workmen are included in the definition of the workman. Those who are doing skilled work, unskilled work, operational, technical, all these people are covered under the definition of the worker. And supervisors who are drawing salary more than 18,000 are excluded. So this is but in the entire code, we will find the term worker is used. Though employee is defined, but most of the provisions are in respect of worker. So one should not get confused with the definition of the employee. Secondly, then we come to most important change they have made is a fixed term employee. So fixed term employee is their new addition is there. Is a worker who is engaged for a fixed period. For example, 2 years, 5 years. So this employee will be for a fixed term period, but conditions will be that he will be paid wages of a permanent worker. All service benefits, conditions of service will same as that of a permanent employee. He will not be given benefits which are less than which are given to a permanent employee doing same or similar work. So this is the important change. So this is the condition for engaging a fixed term employee. Then so far as all the service conditions, he will be same. Gratuity, he will be eligible if he completes 1 year service, fixed term employee. Proportionally, he will get that gratuity. Now, what are the why this the definition of fixed term employee? Now, so that an employer gets a complementary workforce of fixed term employee. Suppose suddenly the production demand increases, then he can engage a fixed term employee for that period, so 6 months, 1 year, 2 years. If he sees that there is a lot of demand, he can engage fixed term period, which is in complement to his regular employees. So this is the idea behind bringing this term fixed term employee. And the fixed term employee has been excluded from the definition of the retrenchment. So once a fixed term employee is engaged, if his period gets over, he will not be a he will not come under the definition of retrenchment. His termination will not come under the definition of the retrenchment. So it will be exclusion part of the definition of the retrenchment. So another important change they have brought is in industry. The definition of industry, they have excluded specifically charitable organizations and organizations which are doing sovereign functions. For example, government is doing some sovereign functions like police, law and order, judiciary. All these are sovereign functions. So these functions which are performed by the government, they will be excluded from the definition of the industry. Though the definition of industry under the Industrial Disputes Act still is under dispute and it is pending before the apex court, before the constitution bench of 7 judges. Now there is a change in the definition of the industry. So that dispute will remain, but then they have made a change in definition of strike. Strike in the strike they have added one clause which says that if a employees go on strike, that is they go on a mutually consented casual leave more than 50%, that will also be as a treated as a strike. Then we come to definition of retrenchment. As earlier explained, they changed the definition of retrenchment, and in the exclusion part they have brought in the term fixed term employee. So fixed term employee is excluded from the definition. Now we come to chapter wise, we will discuss the code. Important chapters, important changes we will be discussing, not entire chapters. So works committee has been made applicable in cases where establishment engages 100 or more workers. So what is the role of the works committee is to promote measures for securing and preserving good relations. So there should be no industrial relations problem. There should be peace, industrial peace. For that, the purpose of the works committee, it will be for only applicable only to industries engaging more than 100 workers, and it will be equal representation of both the workers as well as employers. Both will be equally there. Then grievance redressal committee has been appointed. This grievance redressal committee is for establishment engaging 20 or more workers, and basically it will be in relation for resolving the individual disputes like dismissal, example, retrenchment, all these individual disputes relating to termination, etc. They they may be resolved by this grievance redressal committee. So what is the procedure is that equal number of members will be there of the on worker side as well as on the employer side, both will be equal, and it shall come. This grievance redressal committee will be of 10 employees. The chairman will be one amongst this committee, it will work from it will be alternately, once it will be from employer side and another year it will be from employee side. So if this committee is not able to resolve the dispute, then a worker can go to a straight away to conciliation machinery. And in conciliation machinery, if it is not resolved, then he can file an application straight away to tribunal. Now, the definition of industrial disputes includes individual terminations also. So for individual terminations, retrenchment, it will also be constituted as an industrial dispute. And the limitation period is 2 years. So within 2 years from the date of dismissal, the worker has to approach the conciliation machinery. Now, in the chapter of trade union, that is chapter 3, the provisions remain same so far as application has to be made for registration of trade unions. The eligibility criteria of trade unions remains same, that is minimum 7 members, and in addition to that, 10% of the employees or 100, whichever is less, should be members of that union should be engaged to that industry. So that criteria remains the same. Then other procedural aspects regarding application to be made in format. The declaration should be there for formation of the union, resolution of the union, then objects and trades of the union, constitution, all this while filing, that should be there. Once that remains same, what is the provisions to be made in the constitution, what should be the objects, all this remains same. Now, what they have added is most important thing is section 14. Now, section 14 is very important change they have made. What is section 14 is negotiating council. New concept has been added, negotiating council or negotiating union. Now, in a case of any establishment, industrial establishment, if there is only one union operating and functioning, only one union is operating or functioning, then the employer can recognize such an union as a recognized union. This is the change they have made in. Suppose there are more than one union, then what is the procedure for recognition is that if one union which is having more than 51% of workers on the muster roll who are members of this 51% are members, then in such case this union will be recognized as a negotiating union by the employer. So all these rules will be framed how this negotiating union should be recognized. But in cases where there are more than two unions and one is having more than 51%, then that union will be recognized union. Then comes case where there are more than one union but nobody is having 51% majority. So in that case, they will be forming a negotiating council. And this negotiating council will be represented by all these unions who are having more than 20% membership will get one seat each. So that is how a negotiating council be formed. So if there are four unions having 20% membership each, then there will be 4 members from these 4 unions in that negotiating council. So this is a vital change they have brought in because recognition now under earlier law Industrial Disputes Act there was no provision for recognition of an union. So this recognition of the union gives primacy to the trade union movement. Now what they have done is that this for this recognition union the period is kept from 3 to 5 years. So recognition shall be for 3 to 5 years as may be prescribed. One more important change they have brought in that for what facilities should be provided that will also be prescribed. The industrial establishment have to provide facilities for this negotiating union, maybe like office, etc., premises, and all these things. So this is one more important change they have brought in. Then rest of the provisions remain same. Only one important change they have brought in is section 22 in the Industrial Relations Code, which says that a dispute between two trade unions or a dispute about admission of a worker in a trade union, all such disputes are disputes between Federation of Trade Unions, all these disputes will be now resolved by a tribunal for this purpose. So all these disputes of intra disputes of these trade unions will be resolved by the industrial tribunal. There is tribunal there for that purpose. Now we come to next chapter, chapter 4, standing orders. So these standing orders have now been made applicable to establishments having 300 or more workers on any preceding day preceding 12 months. On before the 12 months, if there are more than 300 workers, then only that an industrial establishment will be covered by standing orders chapter. This is a vital change which they have brought in. Now this will have a large effect on the industries, on workers, and at the same time this will also create a lot of litigation because what happens to industries which are less than 300 if standing orders is not made applicable, then what happens is how then disciplinary inquiry, all this disciplinary inquiry should be conducted, and then all these temporary employees how they may be made permanent, all these issues will be now a matter of judicial litigation, and judicial law will prevail. So the law will evolve the in respect of this employees. So far as other employees who are covered by standing orders, they will, that is in the industries where more than 300 workers are there, they will be governed by the standing orders. Rest of the things remain same. That standing orders, once they are, this code comes into effect, that model standing orders have to be adopted by that by the establishment within 6 months. And if they have to modify the standing orders, they have to make an application to the certifying authority. Then certifying authority will give an opportunity to the union. After hearing both the parties, then certifying authority will certify if the standing orders are found to be in conformity with the model standing orders framed by the government. Then can be addition, but there cannot be a standing order which is in contravention of the model standing orders. Once there is certifying authority certifies standing orders, then it will come into force. There is provision for appeal if the any person is aggrieved by certification of the standing orders. They can go for appeal of the against that standing orders, certified standing orders. And if any dispute arises regarding the interpretation of standing orders, all this will be resolved by the tribunal. Meanwhile, the still the till the certified standing orders comes into force, modern standing orders will automatically apply to an industrial establishment temporarily. And the provisions regarding subsistence allowance remains same. That is, 50% wages will be paid during the first 90 days period of suspension, and 75% of wages if the inquiry prolongs and goes beyond 3 months. Provisions regarding notice of change and all other provisions regarding voluntary reference of disputes, all these are same. Notice of change, you have to give 21 days notice. That provision remains same. If there is agreement between parties, then notice of change is not required. And in case of emergency, without notice of change, it can be done, provided there is consultation with grievance redressal committee, and if such is in accordance with the orders of the appropriate government. Now we come to mechanism for resolution of industrial dispute, that is chapter 7. Now this is most important chapter where they have made a lot of changes. Now earlier in the procedure for industrial dispute resolution was that whenever an industrial dispute is apprehended, or when there is an industrial dispute, in that case, first it will go to the conciliation officer. Then that conciliation officer will try to resolve the dispute between the parties. And if the dispute is not resolved amicably, there is no settlement is reached between the parties, and both the parties are adamant on their own stand, then in that case, the industrial dispute, the conciliation officer will send a report to the government. Then government will see the entire records, and based on that, they will refer the dispute. What is the dispute to be referred to the industrial tribunal, or maybe to the labor court, as the case may be, as per the jurisdiction of the labor court or as the jurisdiction of the industrial tribunal. So this was the procedure which was to be followed under the Industrial Disputes Act 1947. Now what they have done is they have changed that procedure. Now instead of labor courts, there will be one industrial tribunal. Now this industrial tribunal comprise of a bench. One member will be of an administrative side and one will be from a judicial side. So the two-member bench will be appointed for deciding industrial disputes. Or in some cases there will be one member, but he will be either from judicial side or from the administrative side. Now this bench of this industrial tribunal, it will have jurisdiction only in respect of deciding the matters relating to interpretation of standing orders. If there is dispute regarding interpretation of standing orders, then in that case it will be decided by the tribunal. Then, in case of discharge, dismissal, it will be decided by the bench. Then, illegality of strike or lockout, all this will be decided by the tribunal. Then we come to another aspect, that is the retrenchment of worker, trade union disputes, illegality of strike or lockout. All this will be decided by the bench. Rest of the things will be decided by single member bench of the industrial tribunal. So far as disputes which are regarding national importance, where more than one states are involved, in that case there is a national tribunal will be constituted, and this national tribunal will decide the disputes which affect the entire nation. Now, if there is a difference of opinion regarding the judicial members, on the bench, then that dispute will be referred by government to another judicial member or administrative member, and on that point, finally, it will be decided on the basis of the majority. The most important thing is that they, for this industrial disputes, they have brought in the limitation period of 2 years, which was not there earlier. So within 2 years, if dispute is not raised before conciliation, conciliation officer will not have any jurisdiction, and further proceedings, the matter cannot travel to the tribunal. Here, what they have done change is that once you go to conciliation and conciliation fail, the matter will not go to the government. You can straight away file an application before the tribunal. So the process of sending that report to the government and thereafter government referring the matter to the tribunal, that has been done away with. Now straight away, once the conciliation officer uh, sends a failure report, immediately you can file an application to the tribunal. That has to be done within 2 years. Even conciliation officer will not proceed with the conciliation proceedings if that dispute is not within filed within 2 years. The provisions of 17B, which relates to the payment of wages during the pendency of disputes in the High Court, that remains same, that they have incorporated in Section 56. Suppose if award is passed by the tribunal in relation to a dismissal or discharge, then in that case, if the employer travels, if they takes up the matter before High Court or Supreme Court, during the pendency of the matter before the High Court or Supreme Court, the worker will get his full wages. Another important change which they have brought in is that in cases of industrial disputes involving individual workers, like dismissal, discharge or retrenchment, in that case what they have done is that they have provided provision for interim reliefs. So tribunal can grant interim reliefs to the workers, individual workers who have filed application for setting aside his dismissal, discharge or retrenchment. In that cases, the powers are given to the tribunal. Interim reliefs can be provided. So interim relief application can be made, and he can get interim reliefs. Now, so far as settlements are concerned, These settlements and awards. Now settlements, if it's made in the course of conciliation, then it will be binding on all parties. If it is made in a settlement is made otherwise than in conciliation, it will be binding only on the parties who are there to the settlement. It will not be applicable to all workmen. Therefore, that provision remains same. But what they have done is, so far as the settlement signed by a recognized union, which earlier was binding on all workmen, that provision is not there yet. Though they have made provision for recognizing union, negotiating union is there, but the binding effect of a settlement signed with recognized union, that is done away with. So only settlement which is signed in a conciliation proceedings and an award passed by the tribunal is binding on all workmen. Earlier there was provision that a settlement signed with the recognized union will be binding on all workmen, but that has not has been taken away. That is done away. So a settlement or an award will be binding not only on those settlement signed in the conciliation proceedings and award passed by tribunal will be binding on all employees who join after the industrial dispute is raised. So far as recovery of amount, that remains same. The procedure under 33C1 and 33C2, that provisions are same. So there is no if there is existing dispute regarding wages, bonus, etc. And if existing right is there, then a person can straight away file an application under 33C2. Important change which they have brought in is now commencement and conclusion of proceedings. A conciliation proceeding shall be concluded where a settlement is arrived where or conciliation officer records a failure. Now, this will create another litigation because once a conciliation officer records a failure, then immediately the worker or the union has to file an application before the tribunal. Then only he will get the protection under section 33, earlier section 33. Otherwise, there will be a gap. In between that gap, there will be no protection from filing of a application from the end of proceeding conciliation proceedings and filing of a case before a tribunal. Now, one more important change they have made is strikes and lockouts. That strikes and lockout they have made applicable to all establishments, and all establishments, if they want to, any employee wants to go on strike, he has to give notice of at least 14 days, maximum up to 60 days period before striking. And if that notice is given, really speaking, this provision for notice is made, it will make, once the notice is made, if an employer goes to the conciliation, then that he cannot proceed on strike. So virtually this, what is the effect of providing for notice in case of strike or lockout? Both is that once notice is given, and immediately if the employer or the union they go before the conciliation proceedings and invoke conciliation proceedings, then in that case that strike or lockout they cannot proceed with. So virtually this provision defeats the rights of employee to go on strike or of the employer to go on lockout. The strike and lockout both will be illegal when they are commenced or declared in during the pendency of the conciliation proceedings or any industrial dispute proceedings are pending. During that, they cannot go on strike. During the pendency of any agreement or award, they cannot go on strike. Those provisions remain same. Now, layoff and retrenchment and closures. So here they have brought in significant change that layoff and retrenchment and compensation for closure in cases where industrial establishment which are more than 50 and less than 100, their permission is not required. So in that cases, layoff can be done, retrenchment can be done, compensation as provided in the act. All this retrenchment compensation can be made, closure compensation can be made. Closure can be done by giving 60 days notice in establishment where there are less than 300 and more than 50 employees. In such cases, closure can be done by giving notice, which is mandatory. Notice has been to be given to 60 days. Notice has to be given to the government. And so far as industrial establishments where there are more than 300 workmen, only in that cases they have made permission mandatory for layoff, retrenchment, and closure. So if they have met with the demands of the industry and now they have given employer flexibility to, if the business is not working, then he can close down if they by giving 60 days notice. Rest of the procedure for retrenchment and conditions for retrenchment that remains same. You have to give 1 month's notice, pay 15 days salary for each year completed. That procedure remains same for conditions for retrenchment. The last come first go principle for retrenchment, that also remains same. So person who has been junior most, he should be retrenched first and then senior most. All those principles remain same. And even for re-employment of when a vacancy arises, in that case a retrenched employee should be offered first. All these provisions remain same. Provisions relating to transfer of undertakings, that also remains same. So in cases of chapter 10, where more than 300 workers are there, for layoff, retrenchment and compensation, application has to be made to the government. Then government will decide on that application. If that application is rejected, then the employer can file a review or refer the matter for adjudication. All these provisions for taking prior permission for retrenchment, layoff, and compensation, closure compensation remains same so far as employees engaging more than 300 workers are concerned. Now, this workers reskilling fund has been introduced. So once an employee has been retrenched, the employer has to pay uh, you once retrenchment 15 days salary has to be deposited with this fund, workers reskilling fund, and that amount will go to the retrenched employees for purpose of reskilling. Provisions for unfair labor practice remain same. They have made it an offense. Now, since the matter will not be referred by the government, so here there is a scope for workers or unions or employers for filing an application before tribunal where they can claim unfair labor practice. Then they can restrain the claim for restraining the employer from going on from unfair labor practices. So this earlier what was that government was referring the dispute. Now the scope of this industrial dispute will increase because straight away an application has to be filed. Once application is filed, it, it will widen the scope of the industrial dispute. So this is area for worry for the employers. Now we come to offenses and penalties. Now penalties. Now they have made this once there is any offense committed, then it has to be tried by metropolitan magistrate. However, in some cases, government can appoint an officers to decide whether any offences has been committed, and that person can hold an inquiry and he can impose penalty. What are the offences? Suppose there is layoff is done without permission, if retrenchment is carried out without permission, if there is closure in violation of the provisions under section chapter 10, that is without permission, if the employer closes down, in that case that fine will be 1 lakh rupees to 10 lakh rupees. That will be the fine if it is a first offense, and if it is second offense, then it will be double the fine and imprisonment up to 6 months. So far as offenses which are illegal retrenchment, layoff, or illegal closure under chapter 9, or if the transfer is illegal, then the fine is up to 2 lakh rupees, from 50,000 to 2 lakh rupees. And in such case, second time offense, it is double that amount. Similarly, if any person commits unfair labor practices, then the fine will be up to 2 lakh rupees. And if he commits second time, it will be up to 5 lakh rupees. Similarly, the offences relating to trade unions, if the trade unions do not furnish information or give notices as required under the Act, then they are punishable offences. Similarly, if an employer does not submit draft signing orders as required within 6 months, then it is also an offense. And the fine is up to 2 lakh rupees. If any person acts in contravention of standing orders, that is also made an offense. If strike or lockout is carried on illegally, that is also made an offense punishable under the Act. So all these provisions of Act, if violated, then there are penalties provided under the Act. There is provision made for compounding of the offences also. So in cases where there is a provision for fine, in that cases only compounding application can be made. Rest of the provisions for representation of parties before the tribunal remains same. The union can be represent the workers, worker individual can refer. Representation by advocates is not permitted unless worker agrees or if the tribunal permits. That provision remains same. And then protection of service conditions during the pendency of the industrial dispute, that remains same. There cannot be alteration, change, or service conditions, or the dismissal cannot take place unless permission is taken if the dispute is directly in relation to the misconduct, or in cases where it is not connected. Then in that case, it has to be approval application has to be made. So in sum and substance, the provisions are made where application for standing orders. The important changes which have been made is the fixed term employee. So we will sum up this discussion. The important changes which have been made is fixed term employee definition has been added. So employer can engage fixed term employee for his needs of the business. Then then they have made changes as a negotiating union that has been added. So employer can straight away recognize a negotiating union. One doesn't have to go to court for recognition of a union. So in state of Maharashtra, there is an act, MR2 and PLP Act, which provides for recognition. So that act provisions are cumbersome. One has to file an application for recognition that union. It takes years. But in now they have made in the industrial relation code that they have simplified it and made it very easy for employer to recognize a recognized union. So negotiating union can be easily recognized if the procedure may be prescribed under the rules. Further rules may come. But most important thing is the employer will recognize that negotiating union and not the court. Second important changes they have made is in regarding adjudication of the disputes. Is judicial bench will be there. One is from administrative member and another from judicial side. This will also create some confusion for the industry as well as for the workers, because the administrative member, if he is not able to understand the labor laws, then the justice procedure, all this will have impact on the industry as well as the workers. It will take time for all this process to be adopted. Now, so far as procedure for conciliation, you have to first go for conciliation, and then you can straight away file an application before industrial tribunal. You need not go to the government. The most important thing change is made is 2 years limitation period is prescribed. This will be a game changing reform, because within 2 years if a dispute is not raised, then you cannot proceed with that dispute. So industrial dispute has to be filed within period of 2 years. So this is very important. Earlier, if there was no time limit for raising an industrial dispute, so this they have removed, and limitation period has been increased. So far as standing orders are concerned and applicability of standing orders are concerned, that they have made it more than 300 workers. So all these disputes regarding permanency, completion of standing orders from 4C, all these disputes will not be there in cases where employees are more than 300. Even for closure, they have made applicability provisions regarding permission of to be taken. More than 300 workers are required. So these are the all important changes they have made. To sum up, this industrial relation code really will help the industry and as well as workers. With this, I hand over the session to Audumbar.
Thank you, Mr. Sudeep. Thank you very much. It was really like a knowledgeable session which we had today. I will request the participants if they have any questions, you guys can ask it right now. I think Prashant has some question to be asked.
Yes. Yes.
Yes, Prashant.
Yeah. Thanks a lot for this session. And first request is that there are four code changes that I think we have. This is the second code which we are getting the information. Two more codes on that. If we get the information in future, that will be really great for us. And
Right.
second thing that just wanted to check about the fixed term employment. So fixed term employment can maybe employer misuse that putting their own employee into the fixed term employment and renewing it year on year and not making them a permanent in the organization. Is there any kind of maybe provision to stop such kind of unfair practices if it comes out of this law?
See, fixed term employment, even if a person is engaged for, there is you are right, there is possibility of misuse. Now, fixed term employee has been, condition is that he should get benefits of a permanent employee. So, suppose even if it's for 5 years, he will get all the wages which a permanent employee gets. Suppose permanent employee gets 30,000 salary, he will also get 30,000 salary. So in that way, there he is not deprived of permanency. He also there you are right that there will be a lot of misuse. People will instead of making it this as a complementary force, they will more and more use fixed term employees instead of regular employees. That but in an industry, if you engage entire workforce as a fixed term employee, that the industry will not benefit from it. From
Yes,
business
agree.
perspective, if you see, this fixed term employee has to be used as only a complementary workforce.
Yes, nice.
So your regular workforce has to be there. If an employee is not given assurance that he will be getting his work for 10 years, 20 years, then he will not be able to give productivity. So that's this fixed term employee is likely to be misused, but at same time it will create opportunities. Because earlier, why they were not keeping fixed term employees is that immediately the application for permanency will come up. Now here, application for permanency will not be there because standing orders will not be applying in cases where more less than 300 workers are there. And even if standing apart from standing order, this fixed term employees is a case which is it is an exception to retrenchment. So for 5 years, if you engage, then after you renew and again engage for 5-10 years, it will not be any violation of law.
Yes, thanks a lot. And the second thing, just wanted to check that normally in the Contract Labor Act, there were some kind of maybe perennial job under that, maybe some kind of permanency contract worker could have claimed. Here also, is there any possibility fixed term employees also can show that this is the kind of regular job employment, and for which even they can claim the permanency in the future?
That applications can be filed, but as the law which stands today, that is the as per the intention of the legislation is concerned, they are already giving permanency benefits. A fixed term employee will get benefits of permanency. Only his term will be fixed, 5 years, 10 years, whatever it may be, or 2 years as per the requirement of the business. He may file an application, but then if em- employer If the employer has his own regular employment and for meeting those requirements, additional requirements, he can engage fixed term employees. So there should not be any problem for the, even if an application for permanency is filed, he will, that the fixed term employee will not get, because his entire contract is for a fixed term and he gets benefits of permanency. It is not that he is getting less benefits. If he gets less benefits, then he can ask for that benefits.
Yes. Thanks a lot for clarifying.
I think the next question is coming from Mr. Ashwin Bhagwat.
Yeah, hello everyone. So in Maharashtra, there is the MRTU and Pulp Act. We just wanted to understand how, what will the future of the MRTU and Pulp Act? Also, since it's a state act and there are certain matters provided with respect to recognition of trade unions and also unfallible practices, whereas wherein the employees can directly approach the labor court or industrial court for relief. Uh, Now, how will it be gel with the new act? Now, how will the, whether it will continue, or what will be the repercussions of the new act coming into force? Some light on that, please.
See, so far as recognition is concerned, this code provides for a better relief, and it is inconsistent with the provisions of the MR2 and PLP Act. So, in that case, this being a central act, it will overrule the state act. Only this provision is that if that state act, that is Maharashtra Recognition Trade Unions Act, if it is has received assent from the president, that we'll have to check if that is president has if that act has received assent from the president, then in case of Maharashtra, the recognition procedure will remain as under the MRT and PLP Act. Whereas in other states there is no provision for recognition, so that other states the same procedure, new procedure which is prescribed under the code, that is recognition by the employer, that will prevail. And even in Maharashtra, if that act has not get approval from the president, then this procedure of recognition under the code will prevail. And so far as other disputes regarding unfair labor practices, so far as other unfair labor practices are concerned, that will remain as complementary to the industrial disputes. This is industrial relations code.
Thank you, sir.
I think the next question is coming from Manisha Mane.
Hi, good morning, sir. I have one doubt
Good morning.
that fixed term employment and the permanent employment both are the same aspect or the different one. Because I think the
No,
fixed term employment comes under contract labor. So is this applicable? Is this new act applicable to both?
I did not get your query. Can you please repeat the same?
So I have just one doubt that fixed term employment and the permanent employment both are the same aspect or are totally different aspects.
No, the permanent employment is very different. He's a permanent regular employee. If a permanent employee is there, he will retire after attaining the age of 62.
Okay.
That is what a permanent employee is. And fixed term employee is for a fixed period, 5 years, 2 years, 10 years. So that is the fixed term employment. So he once the period gets over, his employment is over.
Okay. Okay, sir. Thank you so much.
I think now Yogesh has some questions here.
Hi, good morning. So I have put up two questions, but one I got the answer for MRTU. So my other question is regarding will this code, new code or MRTU getting abolished or maybe having impact? The union rivalry may increase inside the plants because getting the permanent seat for 20% subscription will be the criteria. Then where will our collective bargaining will go, sir?
Collective bargaining will be there if there are, see, ultimately either there will be one negotiating union who has 51%. You can negotiate with that one union, If one union has no majority, still a negotiating council will be there. You are right that negotiating council, it will be very difficult to negotiate with the negotiating council because this council itself will be having members from different union, and there will be no uniformity or unanimity amongst those negotiating council. So to that aspect, it will affect. But then bargaining power of the employer will increase in such a scenario.
Yeah, that is sure. So it is a like divide and rule game will be there, I think.
Yeah, yeah, you are right.
Thank you.
Any more questions anybody wants to ask?
So I have one question.
Hmm.
Yogesh ji
Yeah.
Yes,
side.
please.
Yogesh ji side. So the question is very simple, but not able to understand whether just now sir has mentioned that the once president has signed the rule, the state government rules will be abolished. It will be over.
No, no, it
Over.
will.
Yeah.
This code will prevail. Industrial relations code will prevail.
Industrial
See,
relation code will prevent.
see,
Okay. So
if
all
that
other.
in that state, if you ask the question, then I answer.
Okay. Okay. Sir, when the president rule is the president's signature is there, then all existing laws will be get abolished, or maybe the industrial code and other codes will be in practice. So, will there any be impact on local rules and state government's rule, or whether state government can say no, we will not implement the same what is happening in some other laws, for example, farmers bill and etc., where we have found that states are opposing.
Here, there is no state government has no option. Here, what those industrial relations code is a central law. Now it will come into force. If there is a state law on same subject, that is recognition law is there in the state of Maharashtra, MRTA Act. Now those provisions, they are inconsistent with the industrial relation code, because under those provisions recognition can be through the court, and the minimum 30% some percentage is there. Here the provisions are different, so there is inconsistency. Now when there is an inconsistency, then central law will prevail. So this code will prevail only when there is a state act, that is Maharashtra MR2 Act. If it is assented by the president, if that bill has been passed by the president, then in state of Maharashtra only the state act, that is MR2 Act, will prevail. So that has to be examined whether that act has been passed by the signature of the president. That has to be examined.
Okay, thank you.
Okay, thank you very much. So, what I'll request the other participants, if they have any more questions, I will request them to please either WhatsApp on 9372886473, or you can also email it on info@legenius.in. All right, we'll make sure that we'll answer your all questions. Yeah. So I will also like tell you one more thing here, that in the next session, which will be happening with Advocate Sujeet Salkar once again, will be about labor law again. The topic will be the Occupational Safety and Health Code 2020. So that is 2020. Okay. Uh, so I will like request all of you to be present that time also. It will be starting by 10 o'clock in the morning on 11th of October. Yeah. And right now, I will just request all the participants, please note down the contact details which are specified on the screen. And I thank you, all of you, to being there, giving your contribution towards this webinar. I thanks Samruddha Bharat Sangh and LEXGENUS for organizing this webinar for all of us and having this kind of valuable knowledge and learning through them. Yeah. All right. Thank you very much.